If you typically were the earning spouse and your spouse did not work during your marriage in New Jersey, it is likely you will be paying alimony. However, we have to look at your spouse's earning capacity. If your spouse stayed at home to raise children for a few years and now those children are older and your spouse can work, your spouse, A, should be looking for work, or B, we can look to impute income to your spouse. If your spouse, for instance, had a job making $100,000 a year several years ago and now quit for even good reasons for a number of years, like to raise children, but now the children are of age that they can have either daycare or are of the age where they can care for themselves after work, there's no reason that your spouse should not be working, or we would try to impute income. Maybe not at the same level, but maybe at the same level or close to that level. So yes, in general, if your spouse is not working, cannot work due to a disability, or has zero qualifications to work and never worked during your marriage, you can expect to pay alimony based upon your spouse earning little or nothing. However, in most cases, your spouse should be earning something, either now or in the future, which will impact your alimony. In many cases, we see arrangements where the paying spouse will pay a little bit more in alimony for the first few years, and then it'll drop because the expectation is that the other spouse can now go out and find employment and better themselves. So with every alimony case, whether your spouse is working or not working, it is fact specific, and we need to look at the facts and apply the factors in the alimony statute to the case to come up with the right amount of alimony, whether you're the receiving or paying spouse. We deal with alimony in almost every case, and it is a huge part of what we do in most cases. So if you have any questions about alimony, whether you're the paying spouse, the receiving spouse, working, non-working, please give us a call here at Callagy Law.